My apologies for that. I was told the sound is off. Sorry about that. Welcome again to this live webinar. Today's topic, general family law questions. And on that bumpy start, we'll deal with question number 1. Let's begin.
Kwazulu Natal. Divorced since 2013. Settlement agreement in place, and through the years the maintenance amount stated on that agreement has changed. This year we relocated and my daughter was given the opportunity to live with her school principal in order to finish her GR7 year in an excellent school. Her father notified me that he will not pay her maintenance to me because she is not in my care. He has not paid it to anyone else either. He gave her pocket money and paid the school fees, which has always been separate from the maintenance amount. Please advise.
Okay, wonderful. So that's question number 2. That person is live on the Zoom. If you are still on the Zoom, you're welcome to unmute your microphone and interact with me and add in additional questions. Basically, the crux of the matter is there's a maintenance order in place, and now the minor child is being cared for by the principal for grade 7, and now the father is saying he does not want to pay maintenance. Am I correct? You can elaborate further if you want to.
Yes, that is correct. He has not given me any of the maintenance, and yeah, as a consequence, I haven't been able to pay any of her costs related to what I had to pay, including her fees for staying at the principal. So nothing's been paid, and he's just giving pocket money and paying school fees, and the maintenance goes nowhere now. And he is of the opinion that that is how it works. And I know that's not right. So I need some advice on how to go forward. What do I need to do? And yeah, obviously I need that money urgently because things need to get paid. Yeah, I just need some advice on that, please.
No, you're welcome. Thank you for proposing that question. The bottom line is you already got a maintenance order, so 99% of the battle has been won. I think that's very important for me to clarify and to note that you have a maintenance order. He is in violation of the maintenance order. He's committing a criminal offense. He's not acting in the child's best interest. So there are two options that can be followed here. Is obviously the criminal route, where you lay a complaint, go to the maintenance court. They will charge him criminally, and ultimately he could go to jail. Most probably won't happen after the first offense, but it's possible up to 3 years. The other one is obviously the civil route, where they can attach his property, garnish your order, take money from him, and so on. So my advice to you at present is approach the maintenance court ASAP, lay a complaint. They'll know what process to follow. Is it the criminal or the civil route? And let him know. I mean, it does not mean that the minor child is now by the principal. You have no expenditure. You still have expenditure. You still have to look after the minor child, pay for certain expenditure. So if he really could not have afforded it, he should have gone to the maintenance court, but he has not done that. So he is in violation of the court order. He is committing a crime, but you as a complainant need to advise the court that something is being happening, a crime is being committed.
Okay. I need to just clarify as well that he is a lawyer himself. He's a lawyer, and I think he's doing this because he thinks I won't do anything because I'm scared because he's a lawyer. And I wouldn't necessarily want to follow the criminal route because I don't want to jeopardize his career. But yeah, so I was wondering also if it's possible for me to have like a personal consultation with you, to book personal consultation, so you can maybe guide me through this process, because I need to do it right. And where I live, I don't necessarily think our court here is up to handling cases like this. I'm not being condescending or anything towards them, but I need proper help. And would it be okay if I book a personal consultation with you to help me?
Okay, so I'll deal with the issue concerning the consultation. Yes, you're always welcome to go to the website. I think it's below me now, www.ourlawyer.co.za/advice. Go to that link. You're welcome to set something up with me. I'll remember this consultation. I'll obviously listen to it again because it's a video, and we can take it from there. So anytime. But going forward, him being a lawyer does not really change the facts of the matter, in the sense of if he follow the criminal route and he pays, then the courts basically they would draw the charge in any event. So he might require someone to the scheme, but I'm dealing with a general advice for everybody that might have this problem, irrespective of the province.
Yes.
So that's the one aspect. It is a court order, he has to adhere. And because if he is an attorney, he's a lawyer, and he knows the law, then he should have applied to the maintenance court long ago, or at least at the start of this year, stipulating that the minor child, according to him, no longer costs that much more money because he believes that the minor child is living free of charge by the principal and the cost is less and therefore he should pay less. But he has not done that, despite him being a lawyer and understanding the law. So, yes, you're welcome to contact me. I'll be happy to assist you. But at the same time, from the court's point of view, I would not be much afraid because what will happen is basically you lay the criminal charge against him, he will pay the arrear maintenance, and there we go on. So I doubt he will be a person that will not do that and take the risk of having a criminal case, a criminal having a sentence against him, put it that way, a conviction of non-complying with the maintenance order. I doubt he will do that. But anyway, I hope to hear from you soon, and I hope this assisted you to some extent.
Thank you. Thank you very much. It is.
You're welcome. Thank you very much. I see there's someone else also on the WhatsApp line. You can just leave a message, sorry, on the Zoom line. You can just leave a message in the chat, advising me which question you are, or your province at least, and the general issue of your question, and I'll be able to relate or relay that specific question to an IT person who can put it on for me and for me to deal with properly. So please message me on the Zoom line. Nonetheless, let's deal with the first question we dealt with. We should have dealt with initially, but we were lucky to have a live person to add some life to this webinar. So the first question is as follows from Western Cape.
Western Cape. I have a restraining order against the mother of my child as she harasses myself and my family. I pay my maintenance, however she refuses to let me see my son. It's been almost a year now and I have reached out to social workers as well as mediation for a parenting plan, but so far, no assistance. Please help.
So I listened to the question, and the challenge I have is I do not know if this matter is currently in the children's court, because my advice to this specific person would be go to the children's court. The person is mentioning that the matter is with social workers and mediation for a parenting plan, but so far no assistance. So I will for 1 second presume the matter is not in the children's court. So approach the children's court and say, I'm getting nowhere with these mediators, with the social workers. Please assist me in finalizing this issue I have here. Alternatively, if the matter is in the children's court and nothing is happening, I would say make some noise there, speak to some supervisor, speak to a senior magistrate and saying, I'm getting nowhere with this issue here, I'm still being harassed, A, B, C, and D, please assist me. Alternatively, if you feel you're going nowhere in the children's court and nothing is happening, I would say withdraw the application and maybe approach the High Court for some type of relief. But the bottom line is, in children's matters, the law expects the courts to deal with these matters expeditiously. That's on principle, that's on paper, but unfortunately it does not necessarily work like that in practice. But my advice to you is make some noise, do what you have to do, let them know that you are serious about your matter and that you would like assistance as soon as possible, and that the system is failing you. So I hope that answers question number one. I have very limited amount of data regarding question number one, but that's my advice to you. Okay, we dealt with question number two. Let us deal with the third question from the Western Cape.
Western Cape. My husband has been paying maintenance for 21 years. The child does not go to school and he has a garnish order that was supposed to stop in November 2021. He went to court for 2 days and filled the paperwork, but the papers were still not delivered to the mother. Can you PLS give advice as to how to stop the garnish order?
Okay, so I presume this is the stepmom or the new wife writing this message on behalf of some advice for a husband. The minor child is 21 years old. The garnish order, I presume, is in terms of a maintenance order, and obviously the garnish order goes with the maintenance order. If the maintenance order said it's only standing until the child is 21 years old, then that is a factual thing. But what's happening here is it was supposed to come to an end in November 2021 when the child turned 21 at least. The child was an adult since 18 years old, but the garnish order is still proceeding. Now, there's a challenge I see here. The order for the garnish order to be cancelled does not get served on the mother. We say over here papers were still not delivered to the mother. It gets delivered to the employer. Because a garnish order is served upon an employer for the employer to first pay the mother in this case, before the salary gets paid to the father. So my advice to you under these circumstances is get hold of that order to cancel the garnish order and go to the sheriff and ask the maintenance, or can you do it? And they will say yes, they should say yes. Well, you go to the sheriff's office and ask the sheriff to please serve this order on the employer, on your husband's employer, and ask him to cancel the garnish order. That's the best way. Serving on the mother won't take the matter any further. I doubt she will take it to the employer and say, I do not want to receive maintenance any longer from my ex-husband. So I hope that answered question number 3. I'll just do some housekeeping quickly. Is there any other questions happening? No. Also, we have some viewers today. And on the Zoom, if you are planning on speaking, you're welcome to just notify me via the chat, and I'll be happy to deal with that. Number 4 from the Eastern Cape.
Eastern Cape. I have a case with my baby's dad. He doesn't want to pay the amount. I went to the court, and when they asked him how much he will afford, he said I don't know. Now he said he wants the lawyer, and he's complaining that I'm not giving the child, whereas he knows very well that in his house they always drunk and fighting with his wife, and he demand that his wife is the one who's supposed to buy my child's clothes. My question, is it a must?
I did not understand the question so well as to the end. Are you referring to the child maintenance issues or care and contact? But I presume, looking at the question, we're dealing with child contact. So the question basically is, seeing that this person is not paying child maintenance and this person is people are drunk and fighting at the home, must the specific mother send the minor child to have contact with the father? It's a very difficult question. I do not necessarily want to comment and say, refuse contact with the minor child to the other parents. They're fighting, they might be drunk. Are they actually, in fact, dangerous for the minor child? I don't know. I'm not here to advise you, and then tomorrow they go to court, and then you will say, for the advocate via the Facebook Live looked at my question and said I should not let the minor child have contact with the parents, with the father in the father's home. What I do advise you to do is contact a social worker, contact a professional person that deals with child care matters, and say, these are the challenges I have, these are the issues I have. Is it in the minor child's best interest for me to let the minor child go to the father and have care and be cared for by the father with his new wife, considering the fact that they're always drunk and they're always fighting? You do not live in that house. You presume that is still the case, and that you presume that they're always drunk and always fighting. And see what the social worker has to say. Then you're basing your decision on a professional. So if the father does take you to court, you can say, but I'm basing it on a professional. If there is a court order in place allowing the father, affording the father contact rights to the minor child on certain days, and you are concerned that despite the court order, the father will be drunk and they'll be fighting, then you need to go to court as soon as possible and have that order varied or set aside. That's very important. You do not want to violate a court order. You need to follow a court order. Everybody has to follow a court order. But if you feel the court order is now impractical or not in a minor child's best interest, you need to approach the court, and the court needs to obviously deal with the matter. So that was question number 5. There are 12 in total, and we're moving quite nicely.
Go ahead. I need a brief summary of citizenship law, democracy, and the Constitution module with regards to you and your family.
I'm a bit confused regarding the question. It could be a law student wanting some answers regarding family law. I do not know. I mean, citizenship in South Africa does not really apply when it comes to the minor child's best interest. And obviously the Children's Act deals with the child's best interest and the Constitution as well. That's all I can comment regarding question number 5. But thank you nonetheless for question number 5. Okay, question number 6 from the Western Cape.
We have a parenting plan in place. Note that normal drop-off on every alternate Sunday is at 5 p.m. With school holidays it's supposed to be 50/50th, so father picks up on Friday and drops the kids the following Friday. This past school holidays, father decided the Sunday he can't take the kids for his school week, and with me pushing back, he ended up dropping kids at my workplace at 9 p.m. on a Sunday night. Note that I was not at work, and he then dropped the kids at my parents' place at 10 p.m. What can I do?
Now, this is a very difficult question to answer. It seems to me the law does not necessarily assist or deal with this type of scenario. If a mother refuses a father contact, or the primary caregiver refuses other parent contact to the minor child, criminal offence immediately. The law kicks in. They can have you charged for non-compliance with a court order. However, if another parent does not want to exercise contact to the minor child, what do you do then? Does the court now force the parent and say, you do not exercise contact in terms of a court order, hereby forcing you to spend time, quality time with your child? Alternatively, can they charge the person criminally because a court order says you are entitled to have contact on a Friday night, but you do not want to have contact, you do not exercise contact? So that's where the law comes in. The law is a bit difficult where that is concerned. It does not assist us much. My advice to you is as follows. If you feel that this is now becoming problematic, what's happening now is the father is cancelling contact, he's not following the parenting plan or the court order that was made, the parenting plan that's made in court or an order of court. He's not doing that, he's not complying with that, and you see problems happening in the future. I would strongly advise you to approach the court and ask the court to have the parenting plan change. The terms of the parenting plan change in the sense of if the father wants to have contact with the minor children, or he cannot have contact with the minor children, he should let you know way in advance because you're the prime caregiver. Of course, he will not be exercising contact on those specific days, and the minor children should remain in the primary caregiver's care. Alternatively, you can make other arrangements for the minor children to live with someone else, be cared for by someone else, and obviously the father has to pay more child support and more maintenance under those circumstances. So that is my advice to you. The parenting plan is obviously problematic. The father makes his own decisions. He does not comply with it. It's not working. If you are saying so, it needs to be changed and the court needs to review it. Call the father and say, how can we change this? So if the father cannot have contact on a certain weekend, he should let you know. You can still enjoy your weekend, but the kids can be with somebody else and he should pay more child maintenance. So that was question number 6, and that takes us halfway. Question number 7.
Western Cape. My husband left me and our baby when she was 4 months old and went overseas. Despite asking him a million times to pay maintenance, he always says he doesn't have money but is a sales director for a big hotel group in Dubai. He has not contributed a cent to our child and I recently lost my job. What is the process of getting him or forcing him legally to pay maintenance?
Okay, a question which I get a lot, and which there's a lot of information regarding this specific topic of parents not paying child support on the internet. Long story short, you need a maintenance order in your favor. The challenge I see here is that the father, you're not saying it specifically, but you're alluding to it. He's a sales director for a big hotel company in Dubai, so he works there, I presume. Now, if you're living in South Africa, in the Western Cape, I presume somewhere in Cape Town, and he's all the way in Dubai, our maintenance courts are structured and function along the lines that people live within South Africa. So you approach the Cape Town Maintenance Court, and the father lives in Johannesburg for argument's sake. They will just subpoena the father in Johannesburg to come all the way down to Cape Town, simple as that. Here we're dealing with this international child maintenance where the other party lives in a different country. The Maintenance Act does not deal with those specific scenarios. A different piece of legislation deals with that. They call it the REMO Act, Reciprocal Enforcement of Maintenance Orders Act. In terms of international law, South Africa has agreements with various other countries whereby we deal with a scenario. If somebody lives in South Africa that's supposed to pay maintenance and the other party is in a different country, we, via diplomatic channels, via the government, via the legal system, we assist parties regarding that. So basically you approach the maintenance court locally, whereby the maintenance court locally will do investigation, look into your situation and come to a maintenance amount. That specific provisional amount will be sent to the maintenance court in the other country where the other party stays, who's supposed to pay maintenance. They'll do an inquiry that side, and everything checks out, they'll make a maintenance order. Now I do not know, and I speak off the cuff of my head, I do not know whether or not Dubai and South Africa has an agreement, but you can double check that. Go on the website, the government's website, type in the REMO, Reciprocal Enforcement of Maintenance Orders. You'll find the Department of Justice's website, and they'll deal with a list of countries that has agreements with South Africa. But nonetheless, even if they do not have that, I would advise you maybe still approach a maintenance court or approach an attorney and ask an attorney to write a letter to the father. Maybe the father will be compliant based upon that. So that's what I would advise you to do. Okay, so approach an attorney, a lawyer, a trust account advocate, whoever can assist you with the specific issue. But at the same time, approach a maintenance court for some advice. They might have some ideas. They might tell you or advise you, no, we have an agreement with Dubai or the Emirates or whatever country he is in, and we can deal with the matter accordingly. So that was question number 8. That was question number 7. Question number 8. Some mention was made of the parties' names, L, M, and Z. I only left the initials in. I do not want people to, use their personal names in here, and obviously we're dealing with minor children, so we want to avoid any potential issues from occurring. So let's deal with question number 8.
Western Cape. Afternoon. My daughter passed away in February 2021. L. My daughter and M were married. M was 5 and Z 5 days. M moved in with my sister where she looked after the children. After 6 months he moved in with his mom. Now we don't see them often. I saw him last November 5, 2021 when a social worker contacted him where he told them not to speak to him but to his lawyer. He doesn't want to meet with me and the social worker. I would love to see them once or twice a month but he refuses.
Okay, we're dealing here with a situation where a grandparent, I would presume a grandmother, would like to have contact with her grandchildren. The mother of the minor children passed away when the younger child was 5 days old and the older child was 5 years old, I presume. Very sad situation. But nonetheless, sometime later, the father does not want the minor children to see the grandmother. The last time the grandmother saw the minor children was on the 5th of November, quite some time ago. Long story short, grandparents by default do not have parental rights and responsibilities over minor children. The grandparents, the people that have responsibilities and rights over minor children, are the parents of the minor child. So you take the parents to the maintenance court. Custody battles are fought out between the parents. You don't cite a grandparent. However, in terms of our law, based upon the fact that we focus on what is in the minor child's best interest, it is possible, and if it is in the minor child's best interest, for a court to assign parental rights on third parties, grandparents, aunts, uncles, step-parents, can be a neighbor also that cared for a minor child. It is possible for a court to do that. Ultimately, you have to convince the court that it would be in a minor child's best interest. So my advice to you as grandmom, and I think, grandmothers have that secondary right. So you have the parents, then you come to the grandparents, then you get to the aunts and uncles. If you go down a ladder, then you go further down, maybe to cousins and so on. You have a very strong case, and I believe it would be in a minor children's best interest in this specific case for you to have reasonable contact with them at least every second weekend, once a month, whatever the case may be, telephonic contact and so on, to have a relationship. The daughter has passed away, yes, that's very sad, but it does not mean the minor child should now leave or lose out on the maternal side of the family. So my advice to you is speak to someone that deals with these type of matters. It's quite specialized. Section 24 or 23 and 24 of the Children's Act deals with it. You can just Google it. The assignment of guardianship rights and rights of care in contact to interested third parties. You have a very strong case, and my advice to you is to go ahead and start the process whereby you can have regular contact with the children of your daughter.
Godhead. What do we do when the father is being denied access to the child? The mother claims her family is the one controlling the situation. The grandmother of the child was the mediator the whole time and now she has passed away. What steps should we follow to make things right?
My advice to you is, on question number 9 from Gauteng, you need to play fast. Maybe approach a mediation firm, company, FAMSA or FAMAC and all those organizations that deals with mediation. Approach him and say, I would like to resolve this matter out of court with the mother to have contact with my child. If that process does not work or it takes too long, my advice to you is approach the court as soon as possible. Don't delay matters. When it comes to issues where parents are being denied contact, mothers or fathers, it happens quite often where the mother's being denied contact or the father's being denied contact. You need to play fast. Do not delay matters. Mediation is a viable option. It's a good way because then the parents can sit on the same table and we can discuss it. Because the last time the mother and the father sat together on the same table and discussed these issues could have been many years ago. Could be 5 years ago. but this could be the first time with a professional person who can umpire the conversation, the consultation, the mediation session. And mom, you talk, father, listen, and he must listen. It's very important that he listens because he won't get a chance to speak. If he heckles and he stops a mom or he stands up and says something, they'll stop him and he loses another 2 minutes or she gets another 2 minutes. So he needs to listen to her, and the same way, when he speaks, she needs to listen to him. It's very important she listens, and they might not meet eye to eye the first session, but the second session after they've gone home and they've, let go some steam, and then they might think, okay, this is the reason why she's saying so, X, Y, and Z, and based upon that, at the second meeting they might be able to, resolve certain issues. But nonetheless, that is my advice to you. Try to mediate this matter, see a professional person. If that does not work, approach the court as soon as possible. Either the Children's Court, see an attorney, and take it from there. Okay, so let's deal with question number 10. Okay, I see the person on the Zoom commented, yes, you're welcome, contact me anytime, and we'll take it from there. Let us deal with question number 10. Oh, question number 10 is quite a long question. Okay, but let's deal with it. Let's do justice to the question. I did not edit this one a lot, but let's do justice.
Got it. After 22 years my husband left me for another woman. At the time he unlawfully evicted me. I didn't know it was against the law then. I ended up giving notice as the lease was on my name just to get to my personal and the kids' stuff. Yet he took everything. Emptied my business account. The car that was supposed to be registered in my company name he registered behind my back in his name. This all happened 2021. End of July he disappeared. Kept on telling me because I can't give him the original marriage certificate, I'm delaying the process. I got a lawyer, but after still no summons he ended up refunding me. My eldest turned 18 last year. She just got her matric results with 3 distinctions. My youngest is turning 18 in February this year. I managed to serve him for maintenance under Rule 58. He basically took my clients because of his lies. I tried to get a job again in the industry I worked for years. However, he worked in the same industry. Due to his misconduct I lost my job again when the final me check came back. I have been unable to find a job since then. He supplied me with stock to continue with the few clients I had left. But it's always on his terms. Leaving me basically with income when it suits him. My eldest daughter filed her own maintenance claim, as he now sees it as a privilege if he pays for her varsity. She got a full scholarship for high school because of academic and sport. She was deputy head. I managed to get the papers signed on him in a parking lot as none of us knows where he lives. After that I am completely without income. I have moved into a house close to varsity because of all the promises that was made. Now I'm stuck with even more bills. I have never denied him to see his kids, yet he has seen them at most 5 hours. And then only in a mall. How do I ensure that he assists with the necessary? I have no income and the amount he pays depends on the day. I also applied for loans purely for business use. To increase stock. He took all the stock as well, yet I'm now stuck with all the loans. Again. No fixed income. Any advice that can help me be ready, as I'm due in court on the 20th of January 2022. He strongly believes that he no longer needs to pay maintenance once they turn 18. As it is, he stopped the eldest pocket money as she is an adult now. Please, any advice would be much appreciated. Thank you. No, he has the money.
Okay, there's quite a lot of things are being said over there. A few points which I picked up. The younger child is turning 18 soon. I think later on in this month. And obviously, once a child turns 18 years old, the child is an adult, and that child cannot form part of divorce proceedings and maintenance proceedings and so on. It is possible, and it happened in the past, where maintenance for that specific child has been agreed upon in a divorce order, the court made it an order of court, but that doesn't happen quite often. Nonetheless, my advice to you is the divorce is pending. I would say, honestly, just get yourself a good attorney. And if you cannot afford a good attorney, make sure that you get your ducks in a row, your finances, your investigation, know exactly what the business is all about. You're not mentioning how you are married, but I'm certain you are entitled to some type of alimony, some type of assistance from the husband. Make sure your case is in order. All the documents are in a row. You have data, you have evidence, you have supporting information, etc. That's where the other party is concerned, but where you are concerned as well, make sure that you have everything in order, you have everything that you require in place so that everything can be presented to the court properly. You are dealing with a messy matter. I think an attorney would be appropriate, as I mentioned earlier on, But even if you do not have an attorney, make sure that everything is presented and before the honorable court. That was question number 10. Question number 11.
Western Cape. Maintenance order that I want to contest. As my ex-wife was working whilst we were married. Now that we are divorced for 3.5 years and I moved on, she's still living with my mother in a second dwelling as property is huge. When I got married last year September, she went ballistic. As I'm not living there right now, I make it my responsibility to get up at 6 a.m. and go fetch in the morning for school. When my ex leaves at 6:30 a.m. or when she works from home, I still do it. So I don't have access to my child when it concerns my weekend with him. I'm blocked by him and her as his WhatsApp messages is linked to her phone. I have absolutely no rights in this settlement as I paid maintenance but cannot have access to my child knowing that she listening in on our conversation. This Christmas had no access. She took him away with no consent as always. Even now never saw him since last year December 23rd.
Okay, another challenging issue we're dealing here with, whereby parents are not, or one part is being very difficult regarding care and contact regarding the minor child. My advice to you strongly is, as soon as possible, approach the court and try to resolve these matters. That's very, very important. I do not think it's a good idea for parents to leave these type of matters, hanging in the air. So the moment there are challenges concerning child maintenance, care and contact, access, visitation, guardianship, it needs to be resolved there and then. We cannot wait for another December, we cannot wait for another Christmas, we cannot wait for another few months of paying child maintenance that they cannot afford. That's very, very important. So my advice to you is, go to the children's court, go to the relevant court, tell them this is the problem I'm having. Despite being divorced for the last 3.5 years, there are still problems regarding care and contact. I'm being refused contact, I'm being denied contact. These are the challenges I have. Please assist me. They'll get both parties in, they'll try to resolve it, and at the end of that process, the court will make a fair and equitable order, at least, for lack of a better term. Regarding the child maintenance, the same way, if you're not happy with it and want to contest it, or you think you can't afford it, or it's unfair, that you should pay for certain expenditure despite 3.5 years when going by and the mother's earning more money, you're earning less money, or the child is costing less, whatever the case may be, or the other party feels you should be paying more money. I'm giving advice to everyone here. Please approach a maintenance court as soon as possible. Maybe send a lawyer's letter out first if you can afford it to an attorney. If you cannot, my advice to you, as soon as possible, approach the court. And the last question, let's read it out.
Good day. The father of my children refuses to pay maintenance for December. I asked.
Okay, that's all that I have. Again, my advice to you is approach a maintenance court as soon as possible. When it comes to child maintenance matters, where the money gets used to feed the child and educate the child and clothe the child, I do not believe there should be any delays in these type of matters. If the other party is not willing to pay, go to the maintenance court, get the process running. You might wait 3 months to get a court date, but in the interim, you can maybe resolve the matter. So when the matter is resolved, you approach a maintenance court on that specific date and you make an order of court. If the matter is not resolved, wonderful, you have a court date. But don't first try to resolve the matter for 3 months. It cannot be resolved. Then approach the maintenance court, and then 3 months later, then you, at your first appearance in the maintenance court, 6 months has gone by, where it could have been, turned into 3 months. So that's my advice to you. Ladies and gentlemen, we've been online now for the last 30 odd minutes. Thank you very much for your time. It's always nice to receive these questions. All those questions that we've dealt with now was sent to us via the link just below the screen, the Word document, www.ourlawyer.co.za/live. You're welcome to do so. I make sure I deal with all questions. Sometimes we let them pack up a bit, but these are the last questions we received. And I hope to see you online again soon. Have a lovely day.